Hello, and welcome to the third episode of TILLY, the interactive lupus link for you. This episodic series is presented by the Lupus Foundation of New England. I'm your host, Marissa Zeppieri-Caruana, and I'm so excited to have you here with us today. We're going to be talking about a topic that is pretty big in the chronic illness world, and I know I have met a lot of lupus patients over the years that have specifically asked about this topic, and that is Social Security and disability. So I'm really excited today to introduce you to Linda Landry. She is a senior attorney with the Disability Law Center in Massachusetts. So thank you, Linda, so much for being here with us today.
Thank you. I'm very happy to be here.
Great. So I'm going to just jump right in, and I'm going to actually hand this over to you. So if you can just give our viewers a little bit of background on your experience as an attorney with Social Security and disability, that would be great.
Thanks. Again, thanks for inviting me. I have been an attorney since the 1980s. I worked in the free legal services programs for a while, and then I moved to the Disability Law Center in 1990, where I have specialized in Social Security disability eligibility, as well as the associated health benefits, Medicaid and Medicare. We do a statewide support system here in Massachusetts for other attorneys and advocates who work with individual folks. So, been doing this for a long time.
Wow, sounds like it. Well, thank you. I'm really excited to have you here today. We have a lot of great questions that we're going to talk about, and I'm just going to kick off with a question that I hear a lot. If someone starts getting sick and is at the journey area of their life, I suppose, where they're at the doctor's, they're having a hard time working the way that they were working, and their doctor mentions disability and potentially looking into disability and starting that process. When someone hears that for the first time, I think they have a lot of questions of, how do I get this going? How do I even find out if I'm eligible? Like, what's the first thing that I do? So what would your advice be for someone in that situation?
Well, the first thing I would do is really talk to my doctor about whether they support a disability application. The disability standard that Social Security uses is quite restrictive. It looks at whether you have a medically documented condition, which means documented by your doctor, ideally by a doctor of the appropriate specialty for the condition, but that's not enough. You also have to show that the condition results in functional limitations, whether they're mental or physical or a combination of both, that really prevent you from doing any significant. And Social Security has a five-step analysis that they look at, and it's useful to know what that is. The first thing they look at is, when you're applying, is, are you actually working at the time you're applying? It doesn't mean you can't do any work, but if you are doing work that Social Security defines as substantial gainful activity, then the application will be denied. And substantial gainful activity is not defined by the number of hours you're working. It's defined by how much money you make in a month. And this year, that is $1,260 gross if you're eligible on the basis of disability, and it's a bit more if you're eligible on the basis of blindness. So again, it's a fairly low standard. And this can be difficult for people who are thinking about applying but are still working, maybe part-time or less, or maybe getting a lot of accommodations from their employer, but they're still making money at the substantial gainful activity level. How can you step away from the income while you're waiting for your Social Security disability to be adjudicated, which can take some time, as we'll talk about later. But if you are not working at the substantial gainful activity level, then Social Security does look at your medical criteria. There is a medical listing where Social Security lists certain medical criteria where they presume that those medical criteria meet their disability standard, the most severe level of disability that's easily documented by just specific medical criteria. And there is one for lupus. I've provided Marissa with a link where you can see the listing for lupus for yourself. But if you don't meet the listing, if you don't have the specific medical criteria that your doctor can document, then they look at your actual functional capacity now. And they look at whether you have the functional capacity to perform the functional criteria of your past jobs. If you can't do that, then you move on. If Social Security thinks you do still have the functional capacity to perform your past work, then you lose right there. You're denied. But if you don't, then they will move on to the next step, which is there any other job for which you are suited, given your functional capacity now, in light of your medical conditions, your age, so it's easier to meet the disability standard at 50 and older than it is for younger folks, the kind of work you've done in the past, whether it's skilled or unskilled, and your educational. So that is the standard, and it's pretty stiff.
Wow, okay, thank you so much for that information. That was a lot of detail. I love that. But so I just want to actually back up for a second. So what you were actually just discussing is SSDI, correct? Because I know that you had told me there are different types of Social Security, SSI, SSDI. So before we move any further, can you just quickly clarify the difference between those and what someone is eligible for?
Excellent point. Yes, the Social Security Administration, which is a federal agency, administers two different kinds of cash benefit programs for people who meet their disability standard. The same disability standard that I just described applies to both of them. The first one that you're talking about, Social Security Disability Insurance, or SSDI, is part of the larger Social Security Insurance Program. It was created by Franklin Delano Roosevelt at the end of the Big Depression back in the 1930s. And the idea was, when we work and pay the Social Security taxes on the work that we do, we are earning insured status for either retirement insurance benefits or disability insurance benefits if we become unable to work due to disability before retirement age. And so that's what SSDI is. It's an insurance program. You have to work a certain amount and pay into the system based on your wages and earn insured status. Most people need 40 credits, which is the equivalent of 10 years of work. The standard is slightly less for people under age 31 who meet the severe standard so that they can qualify. And you also have to have recent work in work covered by Social Security taxes. It's possible to lose your insured status for SSDI if your onset of disability is too far away from the last time you worked in work on which the Social Security taxes were paid. But you can never lose your credits for retirement, just for SSDI. So that's one program. The other program is SSI, Supplemental Security Income. This is the new program. It was created in the 1970, 1971. It is essentially a federal welfare program. It pays benefits for people who meet the disability standard. It pays benefits to people who are older, but it has strict income and asset limits. SSDI doesn't have that. You earn the benefit, you get the benefit. It doesn't matter whether you have a spouse who has income, you still get your benefit. SSI is different. There's a certain amount of money that they will pay. It's only $783 a month this year, and if you have countable income more than that, including a spouse's income, you're not eligible. It's also very restrictive asset limits and very restrictive non-citizen eligibility criteria. But it is there, and often Social Security takes an application for both. Because sometimes there are gaps in your SSDI eligibility. If you meet the financial criteria, you might be eligible for some SSI, and you get automatic Medicaid in Massachusetts, which can help with some of those old medical bills that might not have otherwise been covered. So that answers.
Okay. Oh, absolutely. So, there's so much information with both programs, and I know there's a lot of criteria that has to be met for each one. So I'm curious, we hear about disability attorneys a lot. We see ads for them. I know people that have used them. If someone is just starting the process for a disability attorney, I'm sorry, for applying for disability, is it better from the get-go to have a disability attorney doing this entire process with you, or is that something that you look at more after maybe you're denied and you needed to appeal?
Another great question. It's really a choice. One thing you have to know is that, pardon me, most attorneys charge a fee. They can't, pardon me, allergies. They can't charge a fee unless they win your case. And most of them will ask you to, if they're going to represent you, will ask you to sign a fee agreement where you agree that your part of your retroactive award of benefits, if they win, will be held for the attorney fees. And I think the usual, the fee agreement that Social Security accepts is the lesser of $6,000 or 25% of the retro award. So there's that. Some people might think they can do it on their own if you have a very supportive doctor and your claim isn't very complicated or opaque. Maybe you don't need an attorney. But it can be helpful to have an experienced Social Security attorney, or not, Social Security doesn't represent you, to have an attorney who specializes in Social Security to help you from the get-go. It might result in better evidence collection because they will know exactly what Social Security needs and what the listings say and how the rules work. And can help you do that. And it might be like the convenience of having someone help you apply and talk you through the system and develop the evidence, work with your doctors for you. So it's really a choice, but it can be helpful, and lupus, although it's much better understood than it was when I started doing this back in the 1980s, it still tends to be a condition that has some symptoms that are hard to document, like fatigue or malaise or pain. And it also tends to be subject to periods of exacerbation and remission, where you might function relatively well or totally well in between exacerbations. And so that can be a little difficult in the Social Security adjudication process. It really depends how often you have an exacerbation, how bad it is, and how well you function in between in those situations.
So when someone, we're experiencing these symptoms as lupus patients, if someone is applying for disability, these are things that we're really looking for those to be documented from the person's primary and their rheumatologist or their specialists, or is Social Security gathering all of the medical records from all of their different specialists and looking for these different symptoms?
Well, they should, and some of it depends on how complete your application is. It's important when you're filling out your application to include information about all medical and even some non-medical sources that you may be using who are familiar with how your condition affects you. It's important to keep all of your treating sources up to date with what's going on with you, how often you have symptoms, what works, what doesn't work. Maybe keep a journal about how often you have exacerbations and what it means, but to make sure it is documented. You're right, that's the key. There may be some, you have to have doctor information, MD information, but some non-medical sources, some non-doctor medical sources can also be useful if you get any kind of therapies, or sometimes even non-traditional medicine, where the provider sees you a lot and has enough information to provide Social Security with a credible report about how you function with the condition.
Okay, I think that's great information for our viewers to know. So multiple sources and getting as much information as possible. So the attorney, getting an attorney is one question that we hear a lot. And another question I feel like pretty much everyone asks is, once you start this process, what is an average time frame for an answer? Because I know it is not a quick, a quick answer that you get.
Yes, you're right. It's not quick, and particularly now where Social Security has had to move everybody to work from home, and we don't know how long this is going to go on. It's been a little bumpy, but it all starts with an application. So you can either, if it's SSDI, you can do the whole thing online by yourself or with the assistance of an attorney or advocate, or you can make an appointment at a Social Security office. This can even be done on the phone. They will ask you the questions on the application and fill it out online. These are all done online now. SSI cannot be done online um, um, by individuals or even attorneys, but the SSA staff can do it on. So that can take a while because you need a lot of information about all of your treating sources, the medications you take. A lot of detailed questions are asked about your condition, the history of your condition, the history of your work if you've had a significant work history. So that can take time. It can take weeks or sometimes even a month or two to get an appointment at Social Security to take the application. Then once the application is taken and they've gotten the signed release form so that they can go to the sources you have identified to get medical evidence, that is all sent electronically to a state agency called the Disability Determination Services. They contract with Social Security. They have doctors and examiners who know the rules. You can count on 60 to 90 days there. If your claim is won, terrific. If not, you get a notice and appeal rights. You file the appeal, that's called reconsideration. Another 60 to 90 days back at the DDS, although it can be shorter if you don't provide them any new information, and so they just deny it again. You then get another notice. You have appeal rights. It's always 60 days to appeal these notices, and there's a specific form on SSA's website for every level of appeal if you're doing it yourself. And then the next step is to the administrative law judge stage. And it can take 9 months or longer to even get a hearing scheduled at that stage. It's the most, if you haven't had an attorney before and you have been denied at the initial and reconsideration stages, you probably want to think seriously about getting one to represent you at the administrative law judge hearing. They're set up to be informal hearings, and the administrative law judge is supposed to make sure that the evidence is all captured and all the testimony is captured, but there's nobody like having someone in your corner who knows the rules to help you, to guide you and represent you.
Perfect.
And if you get denied there, then the next step is to the appeals council. It can take at least a year to get a decision from them. It's another paper review, hard to submit new evidence. So it can be a very long period, which is why it's really good to have a really complete application. Make sure your medical records are complete with all the symptoms you reported to your doctor, and by all means tell your doctors that you are applying so that they know to respond. One of the biggest reasons why claims get denied that are allowed later is not enough medical evidence and not enough functional evidence applied with the application or with the appeals.
Okay, well, thank you for adding that in. So just a reminder, one of the largest reasons, excuse me, that you said for denied is not enough of medical evidence. So I want people to be aware just that it is, can be a lengthy process, and to make sure that their doctor understands that they are applying for disability so that things are written down and recorded. And then, like you said, if there are denials and they continue to move through the process, that they might want to consider working with an attorney. So I want to switch gears a little bit. Now, let's say someone goes through the process and they are accepted for a disability, they are approved. You and I had discussed earlier, if they now are getting disability, but for some reason, especially with lupus, like you said, we have these periods of remissions and flares. say they're in a longer period of remission and they feel like they can or they want to start working a little bit. How does that work with working while you're on disability? What are the parameters around that, and how much can you work or earn?
Okay, great question again. And of course, what you can do, how it affects your benefit depends on which benefit you're receiving. So you always have to know whether you're getting SSI or SSDI. For SSI, it's kind of easy to tell people the effect of work on their benefit. Earnings are countable income. And so however much you're working, you just have to know your gross monthly income. About half of that counts to reduce the benefit that you would otherwise be eligible to receive. So if you're getting $783 in SSI and you get a job that pays $900, you might think, well, that'll kick me off of SSI, but it won't, because only about $450 of that $900 is going to count against your SSI. So you could still get the difference between your countable earnings, in this case about $450, and $783 in SSI. So some people get differing amounts of SSI because they have other income, or they have a spouse who has income, or it's a living arrangement issue. SSI is really complicated, but whatever you're getting, about half of your gross monthly income is what's going to reduce your SSI. And when you are working, if you have uncovered medical expenses related to your disability, whether it's an alternative treatment that your insurance doesn't cover, or copays and deductibles, those are called impairment-related work expenses, and those can be deducted from your earnings before they count against your SSI. So that's SSI. If it's SSDI you're getting, then it's a little more complicated. People who get SSDI have a set of 9 months in which they can test their ability to work without any effect at all on their benefit. You even have to earn a certain amount of money in order to use a trial work month. This year, I think it's $900 some. So if you're making $500, you haven't even used one of your trial work month. And you only get one set of 9, and you don't get a new set every time you try a new job. It's just one set of 9. And to make this work, you have to report your wages to Social Security every time you have wages, so that they can count these 9 months for you. And it's because once you've used the 9th month, you can start to lose your benefits with work. And it's that substantial gainful activity number again. After the 9th trial work month, you can lose your benefits in months when you have wages at the substantial gainful activity level. Again, this year that's $1,260 a month gross for folks eligible on the basis of disability. So you have to keep track of that and report it. Now, 3 years after your 9th trial work month, substantial gainful activity results in termination of entitlement to SSDI. So, we don't know what SGA will be in 3 years or even next year. It's based on the cost of living allowance that Social Security uses to increase the benefits, and they also use that to increase the substantial gainful activity threshold. So it's a little more complicated, but people just need to keep good records and make sure they report to Social Security, whether it's SSI or SSDI, whenever they have wages, so that Social Security can either count your use of 9 trial work months or those 36 months that happen after the 9th trial work month, or they can adjust your SSI so you don't get a big overpayment.
So I just want to backtrack on something that you just said. I want to make sure I understand it. If you use those 9 trial work months because you're making more than the standard they have set, yep. It doesn't cancel immediately after that 9 month. There's still time after that.
Absolutely. What happens after the 9th month is you enter this 36-month period where it's just a different work incentive. You don't end up losing entitlement to benefits. You just lose payment status if you have wages at the substantial gainful activity level. The idea is you can go back and forth on benefit payment eligibility for SSDI depending on how much money you're making. So this year, if you're in that 36-month period and you are making $1,000 or even $1,100 a month, you're not losing your benefits in any month. But if you're making $1,280 or $1,300, you're not supposed to get your benefit in those months, but you're not losing entitlement. During those 3 years, if you lose benefits because of your wages, you can get right back on without having to refile an application by going back to Social Security and saying, oh, my wages are less now, please put me back on. And they will do that. But after the 36th month, it's termination of entitlement, and you would have to reapply to regain SSDI if that happens to you. And you can. SSA has created something called expedited reinstatement, where if you have lost benefits solely due to the amount of money you're making, and you again need benefits for the same condition within 5 years, you're eligible for expedited reinstatement. And so it's a faster way back on, and they will even give you up to 6 months of prospective benefits while they do all the paperwork.
Okay, that's very interesting. I'd never heard about that.
Yeah, that's
so
a good incentive.
Right, absolutely. I agree with you. When someone's in that 36-month period that you're talking about, so if they do make too much money and they lose the payment portion, do they still have insurance during that time?
Great question. So the yes, you do keep your insurance during the 36 months. Medicare comes with SSDI, but you have to be eligible for SSDI for 24 months before it starts. Retroactive periods of eligibility count. So often it takes so long to become eligible that the 24-month period for Medicare has passed, and you're eligible as soon as you start getting cash. So you're eligible for Medicare during the trial work months, and you are also eligible during that 36-month period when you're working and maybe losing benefits for some months when it's substantial gainful activity months. In addition, once the 36 months are over, if you are not working at the substantial gainful activity level, then your SSDI continues until the first month that you do have wages at the substantial gainful activity level. And your Medicare continues then. And it also continues if after you lose entitlement to SSDI, if the only reason you lost it was due to your wages. You can keep Medicare, if you want it, for 4 or 5 years. You do have to pay the premiums while you are receiving your benefit. The Medicare Part B premium is taken out of your benefit before you even see it. The Part A premium, which is the hospital benefit, is free to you, and the Part A premium continues to be free to you after you lose SSDI and you're on the continued Medicare. But you do have to pay the Part B premium, and they bill you quarterly. So, it's a few $100s when you get those quarterly payments. So you need to be prepared for that if you want to keep your Medicare.
Wonderful. Well, Linda, you've given us a wealth of information. I am going to post a lot of the links that you sent me, both underneath our video and also at the end of the video. But I just want to give you the opportunity. Is there anything else that maybe we missed for lupus patients, or any advice or encouragement you want to give to any of our viewers that are either about to start the process or are currently in the process of this?
Well, I think just go forward, do the best you can, find help if you think you want it, and again, it can be a matter of convenience. It's just a question of whether or not you think you want to pay the fee, probably. And again, remember, Social Security manages the fee situation, and your attorney can only get paid if you win, and there are limits on how much they can get paid. I will say one thing that's very important that I neglected to say when we were talking about proving disability. And this is especially true with people who have manifestations and remissions. Um, it's important to know that Social Security looks at whether you can sustain work. It's not what you can do on your best day necessarily. It's what you can sustain. Most of us have jobs where our employer expects us to be there uh, uh, 7 or 8 hours a day, 5 days a week, and so forth, the way most people work. So if you can do, if there's going to be too much absenteeism outside of employer standards, which, and that really depends on the kind of job you have, maybe your level of education, about how often you can work from home or be absent from work, and it's okay. But it's also whether you're able to concentrate at work. If you have too much pain or something like that, then you're going to be off task at work. And so that's something that can also be documented. If there's, we call it time off task and absenteeism, that might prevent you from sustaining work activity, even though you're pretty functional on your good days.
Well, I'm glad you added that in, because every day I feel like is an adventure for those of us that have lupus. So it's very hard for us to say what we'll be able to do tomorrow or a week from now or a month from now. So it's nice to know that that's something that they take into consideration. You've been amazing. I just want to thank Linda. She's from the Disability Law Center in Massachusetts, for talking to us today about Social Security. And I want to thank our viewers for joining in to this 3rd episode of the TILLY series from the Lupus Foundation of New England. Stay tuned. The next couple of weeks, we're going to be talking about nutrition. We're going to be having someone on to help us with communication, learning how to communicate with our caregivers and our spouses and our physicians and everyone that we interact with when we live with a chronic illness. So I just want to thank you again, Linda, for being here with us. And for all of our viewers, thanks for tuning in. And I hope that you will come back next week for Tuesdays with Tilly. Take care.